Good afternoon, everybody. I'd like to welcome all of y'all back to Smart Loc TV. I'm your host, the Supreme Litigant, and y'all already know the routine. Before I begin, I'd like for y'all to please, if you haven't already, hit that like button and hit that subscription button. I'll give y'all a second to do that. All right, thank you. Thank you. I appreciate that. So let's just jump right into this. Okay. Today I'm going to be talking about inferior courts and superior courts. This is also the reason why I say there are two Supreme Courts, federal Supreme Courts. I think they're doing this everywhere. I know they're doing it in Alabama. But anyway, I'll explain that a little later in the video. I'm probably going to do another video on this too, just in case I don't get my point across, maybe. But anyway, so I'm going to jump right into this. Alabama constitutional versus legislative courts. I'm just going to use Alabama cases majority of this video. So what y'all need to understand is courts get jurisdiction in two ways, okay? That is the Constitution or a statute. That is it. They don't get jurisdiction any other way. And when I say jurisdiction, I'm talking about subject matter jurisdiction. So jurisdiction is a court's power to decide a case or issue a decree. That power is derived from the Alabama Constitution and the Alabama Code. The code is where the statutes are. Subject matter jurisdiction refers to a court's statutory or constitutional power to adjudicate a case. Subject matter jurisdiction of Alabama courts is conferred only by the provisions of the Alabama Constitution and statute. There is provided in every county in the state a circuit court with all the jurisdiction and powers that are conferred on the circuit court by the Constitution and laws of this state. We have recognized that this court can only act within the jurisdiction conferred by law. By law, they're talking about statute. That's what by law means. And this cannot be enlarged by waiver or consent of the parties. Scroll on down. Okay. Now we're going to talk about the courts that are created by the Constitution. Okay. That will be the superior courts, aka constitutional courts, aka common law courts. There are no statutes being used in this court. All right. Scroll back up. Read this to y'all. But aside from this objection to petitioner's claim, the courts of this state are not only divided into courts superior and inferior. They are of different characters. Some are established by the Constitution itself, that is, by the people. They do not depend on legislative enactment for existence. They are created at the same time and in the same way the legislature, and in the same way with the legislature itself. They are of the same grade in the sovereign power. They are a constituent branch of the government itself. The government under the Constitution is not complete without them. These are the Senate, sitting as a court of impeachment, the Supreme Court, the circuit courts, the chancery courts, and the courts of probate. Now, this is an old case, so they've amended this Constitution, just to let y'all know. These courts do not owe their existence to the legislative power, and the legislature cannot dispense with them or abolish them. They are emphatically the people's courts, and they proceed directly from the sovereign's will. They're talking about the people, just to let you know. They constitute a coordinate and independent department of the government, and there is no other department of the government that can abolish them. The people alone in whom the ultimate sovereign power can do this. Let me rephrase that. The people alone in whom is the ultimate sovereign power can do this. So they're saying that only the people can do this. The people can abolish every branch of government that they don't like whenever the hell they want. They can nullify every Supreme Court decision that they don't like whenever the hell they want because they're sovereign. All three so-called branches of government are administrative agencies of the people because the people created them. They are, in their own way, constitutional elements of the state sovereignty itself, as represented in the government. There are other courts. Let's talk. What do they mean? There are other courts. What do they mean? Let's see what he's talking about. Let's see what this justice held. There are other courts called in the Constitution inferior courts of law and equity, which the General Assembly may from time to time establish. These latter courts derive their existence from legislative enactments. They are creatures of the lawmaking power of the state. Okay. So statutory courts are inferior courts. They are legislative courts. They are akin to administrative courts because they are in there following statutory procedures and they are in there enforcing statutes. They are no longer acting as members of the judiciary. They're acting as executive administrators. They're enforcing statutes and they're exercising quasi-judicial authority. And since they're an administrative agency, they're exercising quasi-legislative authority. They're exercising all three powers of government in these agencies. That's what they're doing. I don't care that they call it a court. It's not a court. Inferior courts, aka statutory courts, aka admiralty courts, aka civil law courts, because admiralty courts are civil law courts, and civil law is statutes and codes. That's what civil law is. The legislature has the power to vest in courts of statutory creation any of the powers or portions of jurisdiction of the chancery or circuit courts to be exercised concurrently. Where a special authority in derogation of the common law is conferred by statute on a court of general jurisdiction, it becomes quod hoc an inferior or limited court, and jurisdictional facts must be shown upon the face of the proceedings. Now, I see this is flying over y'all heads. It's flying over people's heads. Courts of general jurisdiction are created by the Constitution. They are superior courts. Okay? However, when someone files a lawsuit in that court that was created by the Constitution under a statute, that superior court of general jurisdiction is no longer a superior court of general jurisdiction. It becomes quod hoc an inferior or limited court, and jurisdictional facts must be shown on the face of the proceedings. It's an inferior court. It is no longer a constitutional court. It is a legislative court. It is an administrative court. This is why there are two federal Supreme Courts. There are two. Congress created one for their citizens. Their citizens are called U.S. citizens. And in order for you can litigate a case in the United States Supreme Court of America under the Constitution, in which it has original jurisdiction. Original jurisdiction is where the case starts. That's what original jurisdiction means. It's where the case starts. You can do that you would have to cite an article in the Constitution. That's why I posted those cases on my community. Let me show y'all these. Well, I'll do it a little later, but that's why I posted those cases. I'm gonna show y'all the cases a little later. And you can also appeal via a statute to the Supreme Court of the United States. When you use a statute and that court takes cognizance over that statute, that court is no longer acting in the court created by the Constitution. It becomes quod hoc an inferior or limited court, and are y'all following me now? Is this making sense to you now? That's what they're doing, y'all. And this is not just in Alabama. They're doing this everywhere. I'm almost certain that they're doing it. I've seen other cases where they're doing this. Y'all, just to let y'all know. In every constitution of Alabama, there has been a provision for inferior courts. Section 139 Constitution. The Constitution of 1901 made provisions for inferior courts in lieu of justices of the peace courts in certain circumstances. Section 168 Constitution. Let's go down some more. The division of courts recognized that common law was superior, or courts of general jurisdiction, like I just told y'all, and inferior, or courts of limited jurisdiction, like I just told y'all, legislative courts. Superior courts derive much of their jurisdiction from the common law. Inferior courts derive their whole existence and jurisdiction from the statutes constituting them. I think I read something wrong. Superior courts derive much of their jurisdiction. Oh, no, I read that right. From the common law. Hence, nothing was intended to be without the jurisdiction of a superior court, whether of appellate or original jurisdiction, except what appeared to be so, and every presumption consistent with the record was indulged in favor of the regularity and validity of their judgments. While of inferior courts, no intendment was made favorable to their jurisdiction, and a conformity of the law of their creation must have been disclosed by their records. Such was the only division of courts at common law into superior and inferior. It followed from the character of jurisdiction the courts exercised, and not from the subjection of the court to the appellate power of another tribunal. In this last sense, all courts of original jurisdiction are inferior to a court exercising over them appellate power. Scroll down a little bit more. That's not really what I wanted to point out, but I just want to read this to y'all. Let's see. This court has all the elements and all the instrumentalities of a court of record of general jurisdiction within the territorial limits prescribed. It is in jurisdiction, in dignity, and machinery, in officers and process, co-equal with the circuit court. So this is a statutory. Let me see it. I have to read it some more to see what they're talking about. It can be termed an inferior court only because the 8th section of the statute. So this is what they did. This is what they're talking about. The legislature created a legislative court with all of the instrumentalities of a court of record of general jurisdiction. I might be quoting that wrong. I'm gonna leave that alone. I think I might be quoting that wrong. I'm gonna have to read that some more. So I'm gonna stop right there. Let's go down. Let's see. It can be termed an inferior court only because the 8th section of the statute creating it subjects it to the appellate and supervisory jurisdiction, which this court can exercise over the circuit courts and courts of chancery. Okay, if there's a statute in there, then that's an inferior court. They're talking about a statute. It's an inferior court. As above indicated, uncontrolled by the judicial exposition, this clause of the Constitution has received. I think I'm probably gonna skip this because I'm really just trying. I don't want to confuse anybody. And I'm trying to get my point across, so I don't want to get offhand. So I'm gonna read this right here, and then I'm gonna go and read the other cases on my YouTube channel. It has been many times declared that it is within the province of the legislature to establish inferior courts of concurrent jurisdiction with that of the circuit courts, and to provide for the transfer of causes from the circuit court to such inferior courts. An inferior court, within the meaning of Section 139 of the state constitution, giving to the legislature the power to establish the same, is a court whose judgments or decrees may be reviewed by an appellate tribunal, whether that tribunal be the circuit court or other appellate court. And the legislature has the unquestioned power to vest in inferior courts of statutory creation any of the powers or any portions of the jurisdiction of the Court of Chancery or circuit courts to be exercised concurrently with those courts, if the latter are not completely and constitutionally supplanted. So let's go down. I think yeah. Okay. Now I want to talk about superior courts acting under statutes or quad hoc, or however they pronounce it. It's a Latin term. Courts, aka inferior courts. They're inferior courts. It is familiar law that when special statutory authority in derogation of the common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc a court of inferior or limited jurisdiction. The jurisdiction to grant divorces is purely statutory, and courts upon which jurisdiction is conferred in Alabama are quad hoc courts of statutory and limited jurisdiction. Accordingly, while the circuit court is ordinarily a court of general jurisdiction, in the particular proceedings now before us, it is made a court of limited jurisdiction by the statutes. It is the settled rule that where a special authority in derogation of the common law is conferred by statute on a court of general jurisdiction, it becomes quad hoc an inferior or limited court. A compliance with the requisitions of the statute is necessary to its jurisdiction and must appear on the face of the proceedings. So let's go over here. This is how you know that it's not common law jurisdiction. It's admiralty. Just to let y'all know. However, whether the common pleas court, which is a court of general jurisdiction, just to let y'all know, this is another case. This is looks like Ohio. This is an Ohio case, and they're saying the same shit that I just read to y'all in Alabama. However, whether the common pleas court, which is a court of general jurisdiction, was acting in the exercise of such general jurisdiction or was acting in the exercise of a limited jurisdiction bestowed upon it by statute and not belonging to it by the common law, the record shows that it did have. I'm not going to read all that. Y'all can go and read it. It looks like I'm probably about to run out of time, so I'm going to have to hurry up and end this video. I got to delete some stuff off of here. Let's see. Give me a second, y'all. I'll be right back. Back to what I was talking about the Supreme Court earlier. See right here, federal courts derive subject matter jurisdiction from one of two sources. Article 3, which would be the Constitution, or a statute. See what I'm saying? There are two Supreme Courts, federal Supreme Courts. Be right back. Give me a second. A court case. This was in West Virginia. Looks like, West Virginia. They're saying the same thing that I just told y'all about the Alabama case. When a superior court is exercising jurisdiction under a statute, it's no longer a superior court. Go read that. It's telling you the same thing. I'll be right back. Let me pause it again. Okay. Here's another court case out of Maryland that's telling you the same thing that I just said. When a court of general jurisdiction starts exercising jurisdiction under a statute, I'm going to read this one to y'all. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When therefore a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for purposes of such proceeding. And that's out of Corpus Juris Secundum right there. Y'all need to go and read this stuff. There are two Supreme Courts. It looks like there are two of every damn thing from what I'm seeing. Give me a second, y'all. I'll be right back. All right, y'all. Let me read y'all something right quick. Sorry about that. In Macredo, the petitioner filed a habeas corpus petition under the Act. Notice they say Act. Under the Act of 1867, which are statutes, by the way, which conferred upon the Supreme Court appellate jurisdiction in habeas cases. These are statutes. You see that Congress gave their Supreme Court appellate jurisdiction under this Act. Now, this is an old case. You can go and read it for yourself. I'm gonna pause the video again and I'm gonna show you another case. All right, now here's another one. This is a really good one. This will be my last time pausing the video. I'm gonna end it after this. Right here, y'all can go and read that. I'm just reading this in black and white right here. In Felker, the court held that Section 2244B's stripping of the Supreme Court's appellate jurisdiction, that's a statute, by the way, So the Supreme Court was no longer acting as a court of general jurisdiction. It was acting as an inferior court, or a quote hoc court. Just to let y'all know, there are two courts. Anyway, stripping the Supreme Court's appellate jurisdiction to review a court of appeals denial of a state prisoner's motion for leave to file a second habeas petition in the district court did not affect the Supreme Court's original jurisdiction to entertain original habeas petitions. So maybe whoever filed that habeas petition, he probably used an article in the Constitution, because you can do that. When you do it under the Constitution, not statutes, you're doing it under common law. Y'all need to pay attention. That'll be the end of this video. The Supreme Litigant is out. Peace.